Good morning, afternoon, or evening. Here is a Q&A clip in response to someone asking about this question again. So I'm attaching the Q&A clip from a recent live stream session to the public on Q&As, all things Social Security. So take a listen. There might even be some extra tagged onto it of a different video, so you don't have to go searching for it. Thank you so much, and I will talk to you later. Bye-bye.
Okay, Jason says, so with SSDI, you are considered dishonest in their eyes on all accounts unless it is on medical record? No, not at all. What made you think that? It's a matter of proof. So put it this way. Part of the evidence is what you say, like in your statements, like your function report, your application statements, whatever. And then the law that we all vote in, via our Congress and everything else, and the regulations require that the foundation of evidence, you cannot prove disability without it being founded in the medical evidence. Medical evidence. So what we say is not medical evidence. That is non-medical evidence. And the useful part about it generally, Jason, and the irony is, like with the function report, I always say it can be used to sink your ship. It's not going to be used to win your case. And that's fact. It won't be. If a judge is inclined to find that your medical record is strong enough to support an award, so long as your function report doesn't sink that by you saying, well, like, what do you do from the time you wake up to the time you go to bed? Well, every day I have to run my 10 miles. If you say something like that, yeah, well, no, you're not being dishonest, but you are going to lose your case, probably, right? I always say function report is really about protecting your win and not sinking your ship when you have the medical evidence that is required. It's not someone's choice. You can't just hear someone say I'm disabled and then smack them a big piece of the Social Security fund, right? It's got to be through medical evidence, because think about it. 95% of people would probably then claim disability when they're not. And I might be one of them. Just kidding. But you know what I'm saying? I know it's frustrating because it's a very high bar with the medical. And I think part of the problem is because our medical providers are horrendous for the most part in recording what we complain about. Their physical exams seem kind of shabby if they do them. And the fact that their default answers that fill up their progress notes and everything in the record for that visit, all defaults are within normal limits. Default within normal limits. So if they don't go in there and click on it to then take the effort to type in what you complain about, you are within normal limits and you did not complain about that problem. So there are reasons why the medical records are crappy, but it has nothing to do with the law on that.
Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hello and welcome. Okay, we have another circuit court case here, kindly shared by Adriana De La Torre, dated February 11th, 2025. So it's really recent. And of course, she does a fabulous job summing it up and sharing her ideas. I could tell she's not really pleased with this ALJ's decision, it seems like. It's got a few interesting points. And she starts out by saying, could the ALJ have done and said more? And she says, yes, this is what makes this case difficult. Well, I think she's saying that. I'm not sure. Anyway, this is a case of Thorlton versus King, and it's the Seventh Circuit this time. And as you know, I think all the circuits are really important, given that this is federal and everyone pays attention to all the circuits, I think, not just the one you're in. Okay, so it looks like Smithson applied for Social Security disability benefits based on respiratory conditions, particularly asthma and COPD, which rendered him, he claimed, unable to work. His medical history included frequent episodes of shortness of breath and difficulty with prolonged walking and standing. However, the ALJ determined that Smithson retained the RFC, remember that's residual functional capacity, guys. We have a playlist on that, to perform light work. That's the second from the bottom, guys. The bottom one is sedentary work, then it's light, medium, heavy, and there's actually something called very heavy. And light work means standing and walking for up to 6 hours a day. That's a lot of foot time with a light job versus a sedentary, which, as you probably recall, is mostly sitting 6 out of 8 hours a day. The district court did affirm the ALJ's decision, which led to the appeal to the Seventh Circuit. And this circuit emphasized that the claimants, of course, bear the burden of proving their disability, and that its role, the Seventh Circuit, is limited to assessing whether the ALJ's decision is supported by substantial evidence. So the fact that they're emphasizing that, it's a good point. Their role is not to substitute their discretion and their thoughts about whether this person is actually disabled for the judges that was there with the evidence and with the testimony. That's the judge's job. But they will say, well, did he meet the substantial evidence rule? Did that judge have at least substantial evidence to rely upon that he used to support his denial or award, either which way? But their role is limited to deciding whether the ALJ did have substantial evidence upon which he relied or did he not. And substantial evidence, again, is not like 100% conclusive evidence. Very rarely is something, if ever, 100% conclusively proven. We all may feel, very strongly that it's absolutely true, but usually that's not because of 100% conclusive evidence. It's something different than that. Anyway, so Adriana clarifies that their 8-page decision left her with more questions than answers, especially because Joshua, which sounds like that was the claimant, passed away during the appeal. And rest in peace to Joshua. They don't talk about what causes death. It's not mentioned, but she was wondering that if it was linked to his condition, isn't that the very definition of disability? And the point she's bringing up, I believe, is that if we have a condition that causes our death, now he wasn't necessarily considered terminal, but that doesn't mean it didn't cause his death. And maybe it was just going like a train, like the doctors just didn't see it as, in that perspective. So I do think, I had a fellow, well, I've had more than one, but I had one fellow a long time ago who died when we were heading to hearing. I was surprised he had been, denied thus far. And it was along the lines of adrenal insufficiency. And that stuff can really do a number on everything. And we still had to fight this appeal, even though he had passed away. We did end up prevailing, and I don't recall, so long ago, I don't recall if it went back to when we said he was disabled or if maybe they used a birth date or, with an age category change. I don't recall, but I do remember, notwithstanding the fact that he passed away, and it was due to his impairments when you looked at the death certificate, it still took all this time and proving what seems so obvious, but they got to cross their T's and dot their I's, I suppose. Adriana goes on to say there's one part of the opinion that is a small ray of hope in an otherwise gray sky. Claimant can satisfy the burden that limitations were necessary by, quote, presenting testimony about the effect of their symptoms that is consistent with the objective medical evidence. Okay. And that's pursuant to 20 CFR section 404.1529, in particular sections A and C 3 through 4. So a claimant can satisfy the burden of the severity of the functional limitations through their testimony about the effect of their symptoms, and so long as that testimony is consistent with objective medical evidence. So that kind of brings us to a strategy point I would be pursuing, and we do, is that when you see medical records pointing to X, Y, or Z, definitely prepare yourself to be providing, and this, by the way, could be in your function report too, but particularly if you're going to a hearing, using those as kind of like triggers or alerts of the things you want to touch on at hearing. You can pick which things you want to talk about. The judge may be asking you questions, or your lawyer, of course, but your lawyer is probably going to want to ask you about the symptoms that come with stuff that is clearly seen in the objective medical evidence. So there's a tie-in, we know the objective medical evidence is there, and how do you show the limitations and symptoms? That's where that function report that you did 2 years ago is really, really important to not screw it up. Don't take it lightly. I always harp on it because it's so important for later, and this is exactly why. And that's why we are really, really kind of nitpickers when it comes to my clients' function reports and making sure that they're not leaving anything out that would be important, but also not taking up space that would be innocuous and unhelpful either. It's kind of a threading of a needle of sorts at times. But anyway, this case is going directly to that point, connecting your verbiage as a claimant with set exact things that are in your medical records. Those objective could be diagnostics. It could be observations of the doctor. When he has look in the physical examination section. I go directly there. Review of systems has its merits too, because that's what you've been complaining about all along usually. So you want to always be, taking that to heart when you give those to your doctor, if you have to do it like a pre-register with your portal, for instance, or if they have a checklist. Some people are still using clipboards at the doctor's office, but that's where, your ongoing complaints of symptoms can be found in there. And they're found today, and you were complaining about them 18 months ago. And of course, the function report, very important. And then your testimony at hearing. tie it all in together. It takes a little preparation. She notes, this is Adriana, the acknowledgement matters. It reinforces that a claimant's testimony is evidence. It's not medical evidence, but it's the testimony that's going to connect your limitations to actually objective evidence in there. And when it's consistent with medical records, it is substance. And then she points out a problem. The ALJ's analysis felt thin. The court outlined the facts, but didn't connect them. No bridge between symptoms and limitations, no thorough engagement with the testimony. And the court knew this because they said, and I quote, could the ALJ have done and said more? Yes, and that is what makes this case difficult. Okay, so that quote was right from the circuit court. Wow. So then she said she has questions too. Could the court have dug deeper? Maybe. Could Joshua have actually completed 6 hours of standing and walking every day? And this is the point she's bringing up about that. Being able to stand 6 hours out of 8, which means a light job, you have to be able to do it on a sustained basis. And it is something that I think, with all due respect, I do think some ALJs gloss that over. Let's say someone can do it a few days and then they're going to be dying by day 4. Or they could do it for a few weeks as everything got worse and worse and worse. And then they're not going to last a sustained basis such as 6 months. So it is really, I think it's important. And we do talk about this, myself and my clients, could you do, and I actually ask them to sometimes test themselves if it's safe to do so. If the doctor hasn't contraindicated that, stand there for 6 hours, stand at your counter, Most of them aren't going to make it 6 hours. When it starts getting more than just mildly uncomfortable, now wow, gee, I didn't realize I could only go 35 minutes. Because it's not supposed to be where you test yourself till you're falling down, It's when it's unreasonably uncomfortable, where you would probably not be doing your job, adequately. Maybe you would be getting irritable and snapping at people, Maybe the job doesn't take a lot of concentration, but it does take some manners, And when we're in pain, we sometimes lash out. I know when I'm in pain. I know when I had some of you know, when I had my gallbladder out, surprise, surprise, in early September. And then a couple weeks later, I was out of state working in North Carolina and I had to go into the emergency. And I was there for 3 days because apparently I had more stones. And I was in such pain at the end of the second day because they had failed to apparently give me the medication they could have to ease the pain until my procedure, which was to pull out these wayward stones. It was a long-term pain. So, you're starting to lose your mind. I remember saying to the nurse, when she was very sweet, but she's the one that had screwed up my meds. And I hadn't been in the hospital since my C-section 16 years ago. So it was like, and she's like, oh, how are you doing? I told her I'd rather stick hot pins in my eyeballs. My husband looked at me like, oh my God. But that was how bad it was. Like, you can get a little snippy when you're in big pain. And that would be not conducive to a job with the public and not necessarily with coworkers, potentially. If it's something that's going to happen on a daily or multi-weekly basis, when you are, hurting morale because you can't keep your mouth shut because you're in so much pain and you're snapping at people. Just saying, it's things to consider, and don't be shy with your doctors when you talk about it. It might be something you see a therapist for. I hate to say it if that's not something you want to do, but it's just an idea at times for the purpose, by the way, of evidence, not for the purpose of telling you how you should medically treat at all. I'm not a medical expert by any means, but a legal evidence, that's kind of my thing. So we just have to know how to build it, guys. So as she said, we'll never know if Joshua could have completed 6 hours of standing and walking every day. But she says that's not the point, even though it should be, because this case is a reminder that Social Security decisions aren't abstract legal exercises. They're about real lives hanging in the balance. And sometimes the hardest part isn't what's written in the opinion, it's what's missing. And I would say that's true. I think, and this is just a subjective impression I've had over the many years I've been doing this. If I find that the ALJ will often ask more questions about your difficulty standing for a long time and go deeper when he believes you're disabled and he wants to get that verbiage about your limitations from you. And if maybe he's not inclined to do that, he's going to leave it quiet. This is why it's really important that your advocate, your attorney or non-attorney rep, knows to bring out these questions and bring them up. That's really what hearing prep is about. And if you are self-representing, you can do this yourself. It's not that you're going to ask the questions of yourself in front of the judge, like you're talking to yourself, but you can have a list of all the things that you need to talk about. Like, I can't, stand and walk for 6 hours, Judge, I get in so much pain after like 45 minutes or whatever your situation is. You're going to want to talk about those things and connect them to all those different work-related tasks. If you don't know which ones I'm talking about, you could always go to your function report. Look at number 20. It's got that whole slew of columns of work-related tasks that are required to some degree or another, and in some variation or another with all jobs. Some of those are going to be required for every single job, not necessarily everything required for. And you can use those. And I always say, think about when it comes to your limitations, can you do that task as fast, as comfortably, as durationally, or as repetitive as you could when you were 20? And the reason why I put it that way is because a lot of people blow off. I was just working on, well, it was with an application, but I always have the person's information that would be used for their function report later with me when we're putting together an application, because so many things can tie back to it. And I like to have it all before we start. I want everything to be super, super thorough. And if there's an inconsistency, I know to look it up and discuss it then to find out what the scoop is. The person had complained about shoulder pain in one section of something that I give them when I'm gathering data. It's a body chart. It works wonders to get me information that they would otherwise probably forget to tell me about. But under section 20, reaching was not on there. So we actually had a discussion about it today. And today's Sunday, by the way. But yes, I do the Sundays. And so, you leave things out thinking, well, I didn't really need that for my job. Therefore, no, it's not affected. Reaching is not affected. Well, it is for all the other jobs that you have to also prove that you can't do. And you can look at that section to get some of these tasks that you're supposed to be describing if they are not, basically you're describing if they're notably not able to be done all day long. That's the starting point for me. Can you do it all day long? Oh, no? Okay, so we have an impairment of some kind. It doesn't matter if it's degenerative, age-related. It doesn't matter. People say, but that wasn't caused by my work. I'm like, this isn't workers' comp. Don't confuse the two areas of law. Not workers' comp. Okay, that's a really good case. I just love the way she pulls out the usable pieces like this. And honestly, I wouldn't be able to get to all these. So I love it. And thank you so much, Adriana. You're so good at this. And she really pulls out the really salient points that we can all use, whether we're representatives or claimants representing themselves. Okay, guys? Okay, so that was, what did he say? Smithson? I wonder why it's called Thorlton versus King. I bet you because it was a substituted party because he passed. Just throwing that out there. If it was Smithson was the claimant, but the case is now called Thorlton, Thorlton. I know when we have on the very, very sad times when a claimant passes away while we still have a pending claim. It doesn't happen that often, but it does happen, and it's really upsetting, and for their families, and we get a little knocked around here as well. It's never a good sign here when that happens. I believe it must be the substituted party, which would be usually a family member, but that's probably why there's a difference in name. Okay, just thought I'd toss that in there. I'll talk to you guys later. Have a good one. Bye. I can get it to turn off.